A Treatise on Equitable Remedies. Chapter 25. Injunctions to Protect Easements. Analysis. Section 543. Nature and extent of the equity jurisdiction. The jurisdiction of equity over easements, as in trespass and nuisance, is for the protection of legal rights for the infringement of which legal remedies are inadequate. In the earlier cases, at least, it was thought that this limitation made the right to equitable relief markedly less extensive than the right to an action at law. In a leading case, Lord Eldon, in a suit to enjoin obscuring ancient lights, said, "The foundation of this jurisdiction, interfering by injunction, is that head of mischief, alluded to by Lord Hardwicke, that sort of material injury to the comfort of those who dwell in the neighbouring house, requiring the application of a power to prevent, as well as remedy, an evil for which damages, more or less, would be given in an action at law. An action on the case might be maintained in many cases which would not support an injunction." In contrast to this cautious statement of the jurisdiction, it was recently said by an American court, "Injunction is uniformly held to be a proper remedy to protect against an interference with the enjoyment of an easement." Of the two statements, the latter more nearly represents the present state of the law. So far is this true, indeed, that the tendency of the courts is to take jurisdiction to enjoin disturbance of easements as a matter of course, without discussion of the grounds of the jurisdiction. The explanation of the change doubtless is that, when once the jurisdiction of equity was established, it was found that most cases could be shown to be incapable of adequate legal remedy, and hence came into equity. Section 544. Grounds of the jurisdiction. Irreparable injury. The particular forms in which this inadequacy of the legal remedy manifests itself are substantially the same as in other torts which equity will enjoin. Chief among them, as shown in the decided cases, is that of irreparable injury, which, here as elsewhere, means a destructive act to property of such peculiar character or use that its loss would not be adequately recompensed by the damages a jury's verdict would give. From the nature of easements, their disturbance, if other than temporary, is necessarily destructive, and because the easement is always connected with the use of real property, it is generally per se possessed of the peculiar quality which is not adequately to be paid for in damages. Thus, in granting an injunction against the filling up of part of a reservoir, and thereby interfering with the plaintiff's easement in it, the court said, the plaintiffs have no adequate remedy at law. Insofar as the preservation of the reservoir for holding water is beneficial to the running of their mill, the plaintiffs have the right to maintain the same according to the agreements, stipulations, conditions, and covenants mentioned. The injury complained of goes to the impairment of the use of the property belonging to the plaintiff. And the same idea is expressed in this sentence from another case in which the obstruction of a right-of-way was enjoined. No action of damages can give adequate redress to a party who is hemmed in so as to have no passage of egress from his own farm. The free exercise of the right to an easement is generally essential to the enjoyment or beneficial use of land with which it is connected. Hence, in most of the cases in which the question of jurisdiction is discussed at all, the ground of equitable interference is said to be the prevention of irreparable injury. Section 545. Prevention of multiplicity of suits. A second ground of jurisdiction to enjoin disturbance of easements is the prevention of multiplicity of suits. This ground of jurisdiction, while entirely different in character from that of irreparable injury, is very apt to be present with it in the facts of most cases. It is the element of continuance or permanence that causes repeated and harassing litigation, to prevent which is the purpose of equity in enjoining because of multiplicity of suits. In many cases, irreparable injury, too, is present only because the infringement is permanent or, at least, of considerable duration, when a merely temporary infringement would not be irreparable because it would not amount to a destructive act. Such are cases of obstruction of ancient lights or of a right-of-way. Hence the ground of jurisdiction is sometimes so expressed that it is not clear which of the two is meant, and it is doubtless generally true that the jurisdiction can be rested on either or both of them. Occasionally, however, the court makes a clear distinction between them. Thus in Hack's appeal the court said, it is not necessary that the plaintiff should prove damage in order to entitle him to his property. The obstruction of a way by the owner of the land differs widely from the maintenance of a mill or factory which is in itself lawful, but by its noise, fumes or odors, becomes a private nuisance to a person in the vicinity. In the latter case the question of irreparable damage enters, and often a court of equity will not interfere. Richard's Appeal, 57 Pascals Street 105, 98 AM. December 202. The doctrine of that case applies to many other kinds of business, but not where a man buys land subject to an easement, or grants an easement. He cannot appropriate such property against an owner's will and say, I will compensate him in damages. A judgment for damages does not transfer the plaintiff's property in the way to the defendant, as would a judgment in trevor or trespass for taking goods. Nor will the law restore the enjoyment to the owner. He may have repeated actions for damages, and neither gain enjoyment nor lose his right thereto. The law does not offer an adequate remedy. He is entitled to a remedy that will restore him to enjoyment, and is not confined to actions at law for damages resulting from obstructions, and other cases in which the court's notion of the inadequacy of the legal remedy in the particular situations before them was that it could only give damages from time to time in repeated actions, thus causing a needless and harmful multiplicity of suits, are not uncommon. It is this class of cases that marks the great advance of modern law over that stated in the dictum of Lord Eldon above quoted. Section 546. Other forms of inadequacy of legal remedy. Almost all the cases of injunctions against infringement of easements in which the question of jurisdiction is noticed are put upon one of the two grounds already discussed. But no more than in cases of trespass or nuisance do these two forms necessarily exhaust the possibilities of form in which inadequacy of the legal remedy may manifest itself, and this, in whatever form, is always the fundamental test of the jurisdiction. That the cases on easements are so largely in the two classes is, perhaps, partly because they are comparatively few in number, partly because the states of facts are of narrow range and very similar in characteristics. But even here illustrations of an inadequacy of the legal remedy for other reasons than those already mentioned are to be found. Thus, in a very recent case the court said, where the facts are of such a nature as to render the measure of damages speculative and impossible to ascertain with any degree of certainty, equitable relief is seldom denied. This means that when the verdict of a jury necessarily would be in the nature of conjecture as to the amount of damages, a sufficient ground of jurisdiction is shown, and an injunction will be granted also to prevent the taking of an easement for public purposes without first making compensation. Section 547. Illustrations. Interference with rights of way are among the most common disturbances of easements enjoined in equity, and this interference may be, as it usually is, by obstruction, total or partial, or by other means which render the use of the way less beneficial than it should be. Another large class of cases is that in which injunctions are granted against obstructions of easements of light and air, often in England, ancient lights, in this country, easements created by grant or covenant, or those which all abutters have over public highways. Another considerable group of cases is that having to do with easements connected with water, as where one has a right to have water come to him through a ditch, raceway, or canal on another's land, or an easement to divert water from its natural course, or to have flood waters flow off over another's land, or an easement of drainage, or an easement in a reservoir. Public easements, as rights of common, or the right to have a public square free from buildings or other encroachments, are also protected by injunction, and this may be procured by a private individual who shows special injury to himself, just as public nuisances may be enjoined by private parties. Easements of support, as in a party wall, and easements of access to a street or highway are other cases in which injunctions have been granted. A mere license when acted on so as to create an estoppel will also be protected by injunction as if it were an easement. This list is not exhaustive, but it includes the more common classes of cases in which injunctions to prevent disturbance of easements have been issued. On the other hand, one who has a right to an easement may be denied equitable relief for its disturbance because of his own inequitable conduct in reference to it, and he himself will be enjoined at the suit of the owner of the servant tenement if he attempts to increase the easement, to which he is entitled, beyond its rightful limits. In such case he is a trespasser. Section 548. The damage necessary to support an injunction. As a matter of reason, it would seem that consistently with the ground of equity to enjoin a continuing tort in order to prevent multiplicity of suits, no discussion of the amount of damage to justify an injunction would be required, that the question in every case would be the purely legal one: what damage is necessary to sustain an action at law? And the rule thus ascertained would control inequity when the wrong complained of is a continuing or recurring one. It has been shown that in dealing with cases of nuisance this is the ground the courts take. Hence, for example, a pollution of air will be enjoined only if it causes actual damage to the plaintiff, but a pollution of water may be enjoined, though it causes no such damage. This being the distinction generally made between the two cases in actions at law. In cases of easements, however, this rule of the equity courts has not been followed. The language of Lord Eldon in Attorney General v. Nicol is apparently responsible for the anomalous state of the law. That, it will be remembered, was a case of obstruction of ancient lights. The cases in which the question arose of the amount of damage necessary to sustain an injunction seem to have been almost exclusively cases of the same sort, with the result that Lord Eldon's dictum has been reduced to a rule of law expressed as follows: we must not always give relief. It was so laid down by Lord Eldon and by Lord Westburn, where there would be relief given at law. Having considered it in every possible way, I cannot myself arrive at any other conclusion than this, that where substantial damages would be given at law as distinguished from some small sum of £5, £10, or £20, this court will interpose. This doctrine has been recognized frequently by the English courts, though sometimes in language which indicates doubts of its soundness, and there is at least one case which seems hardly reconcilable with it. In America what authority there is has divided on the question, though most of the cases adopt the view that substantial damage is necessary to support an injunction. Section 549. Previous trial at law. The effect on the plaintiff's right to an injunction of the fact that his legal right has not been settled previously in a suit at law, is the same as in cases of nuisance. As is pointed out in the discussion of that subject, the question is not involved in the granting or refusing of temporary injunctions. On application for a permanent injunction, if the plaintiff's right is admitted by the defendant, a judgment at law is not required, as it is obviously unnecessary in such case. So, too, though the defendant denies the plaintiff's right or the fact of a disturbance of it, yet if, on the evidence before it, the court is of the opinion that there is no substantial dispute, but, indeed, that the plaintiff's right is clear, the injunction will issue. The defendant's right to a trial at law at best extends no further than to doubtful questions. And even when the questions in dispute are doubtful, the court of equity will pass on them, if both parties consent or submit to the jurisdiction. When, however, there is a substantial dispute between the parties, and they have not submitted to have it decided by the equity proceedings, the equity court will generally require the plaintiff to establish his right at law before granting an injunction. This rule is one of expediency and policy based on the reluctance of equity to decide purely legal questions, and there is a tendency to disregard it in modern cases, even in the restricted form above stated. Accordingly, it has been said that the equity court should itself determine the legal questions involved as an incident to its determination of the propriety of granting an injunction. In another case, the court remarked, the point disputed is the character of the use which he is entitled to make of the way, a question, not of fact to be found by a jury, but of law to be determined by a court upon inspection of the alleged grant. And it has also been held that an injunction may issue without trial at law if the plaintiff has long enjoyed the privilege, interference with which is complained of. Section 550. Threatened disturbances. Nature of the threat. In dealing with cases of threatened disturbances of easements, the courts apply the requirement usual to cases of threatened injuries, viz., that there must be imminent danger of the wrong occurring. Hence, when the defendant had erected a hoarding which obstructed the light coming to the plaintiff's building over the defendant's premises, for the purpose of testing the plaintiff's right, an injunction against the erection of a building of the same height as the hoarding was refused on the ground that there was no threat of erecting such a building, although the defendant was required to give an undertaking to give notice of his intention to build, and liberty to apply for an injunction was reserved to the plaintiff. If a defendant is planning to build, however, that is a sufficient threat, and an injunction may be procured before the building is even commenced. So it is held that a sufficient threat is shown if the defendant merely claims the right to do the anticipated wrongful act, although he denies any present intention to act upon it, or, if a wrongful act is being done, it seems that is a sufficient threat of intention to repeat it, even if it were put an end to by abatement in a suit at law or otherwise. Section 551. Nature of the injury threatened. The character of the threatened injury which will justify an injunction is simply that which would support an injunction on any ground, if it were already being done. Thus in an English case of apprehended obstruction of ancient lights, the court, after stating the principles which govern the subject, continued, "The application of these principles is far more easy when the building which is complained of has been erected and damages only are claimed, but they have to be applied when the plaintiff comes for an injunction before the building has been erected. It is the duty of the court to arrive at the best conclusion it can upon the effect which the proposed building, if erected, would produce, and if the court is satisfied that in that event the plaintiff would have a good cause of action, the plaintiff is entitled, as a matter of right, to an injunction to prevent the defendant from interfering with his ancient light, or, in other words, to restrain the defendant from committing a wrongful act. Hence, if the threat is only of such a tort as would give jurisdiction to a court of equity for the purpose of preventing multiplicity of suits, an injunction will nevertheless issue. Section 552. The balance of injury. The question how far a court should be influenced in its decision, whether to grant or to refuse an injunction, by a comparison of the injury to the defendant from granting it with the injury to the plaintiff from refusing it, has aspects very similar to those presented by the same question in cases of trespass. On the one side, there is the argument against granting injunctions which are oppressive or harsh to the defendant; on the other, the consideration that to refuse the injunction is to compel the plaintiff to sell his property against his will at a valuation, and that, too, in a case in which his legal remedy is admittedly inadequate, for the question does not rise, of course, till the jurisdiction of equity over the particular case has been established. It is probable that the apparent discrepancies between the cases on this point may, to some extent at least, be explained by the fact that the courts tend to give effect to the considerations which, in the particular case before them, outweigh on one side or the other, without a full discussion of the limits of the doctrine. Hence, it is not strange that as fairly typical cases as are to be found on both sides of the question come from the same jurisdiction. Thus, in one Massachusetts case the court refused an injunction to remove buildings, because they had been erected innocently, and, as the plaintiff's tenancy was shortly to expire, the injury to him would be very small if the injunction were refused. But when the defendant continued to erect an obstruction over the plaintiff's right-of-way, knowing the plaintiff contested his right to do so, and the damage to the plaintiff was substantial, the same court granted an injunction, although the damage to the defendant from doing so was more than twice that which the plaintiff would have suffered from its refusal. And the Supreme Court of Michigan, in a bill to enjoin the defendant from encroaching 3 inches on the plaintiff's right-of-way for the purpose of improving his building, refused injunction because the defendant had begun his improvements, at least, in good faith, and the encroachment did not seriously interfere with the right-of-way, while enjoining it would have been a serious damage to the defendant. But when the defendant proposed to change a stairway in which the plaintiff had an easement, and, pending a suit to enjoin him, actually did so, the same court compelled him to restore the stairway as it had been before, although to do so cost a large sum of money, while the testimony was contradictory whether the plaintiff would suffer any serious injury from the change of the easement or not. None of these cases make a full statement of the conditions under which the balance of injury shall be considered. They all agree in one particular, however, viz. That the defendant who would claim its consideration in his favor must have committed the tort innocently. A willful wrongdoer is entitled to claim no favor. Doubtless all courts will agree, too, in holding that it shall not have any weight against an injury to the plaintiff of an irreparable character, and probably it will be held that the disproportion of injury to be done by granting the injunction or by refusing it must be very strong in favor of the defendant, to bar granting it. For in cases in which the legal remedy is admittedly inadequate, courts of equity will not readily permit a wrongdoer to compel innocent persons to sell their right at a valuation. Section 553. Plaintiff's right an absolute one. Defenses to infringements of easements are often attempted on the theory that the plaintiff has no right to a definite thing, at least not so far as equitable protection is concerned, but only to a certain amount of utility or convenience over the defendant's land. This argument has been steadfastly denied by the courts, on the ground that the plaintiff has a definite property right, which he may protect just as he may his ownership of land. Hence, it has been held no defense to a bill that the plaintiff had more light or a more extensive right of way than he needed, and so was not entitled to enjoin an obstruction. Nor can the defendant justify on the ground that he is willing to give the plaintiff something equally beneficial but different from that to which the plaintiff has a legal right, as an aqueduct in place of a ditch. It is the duty of the courts, said the judge in this case, to protect a party in the enjoyment of his private property, not to license a trespass upon such property, or to compel the owner to exchange the same for other property to answer private purposes or necessities. And it has been held the same way with reference to giving reflected light instead of the direct rays to which the plaintiff was entitled, and which the defendant's building obstructed. Nor can the defendant take advantage of the fact that the plaintiff is himself obstructing his easement. It is nothing to the defendant what the plaintiff may wish to do with his own property. Within the same general principle are the cases in which it is urged that the plaintiff is not entitled to an injunction because he can easily obviate the injury by means of his own. This argument is admissible, if at all, only within very narrow limits. Thus, when it was argued that the plaintiffs should not be given an injunction against interference with their light because they might have made their windows larger, the court said, I apprehend it is not for the defendants to tell the plaintiffs how they are to construct their house, and to say, you can avoid this injury by doing something for which you would have no protection. If the plaintiffs constructed their new window, it could be immediately obstructed as being a new window. They have a right already acquired by their old existing window. That right they wish to have preserved intact, and I think they are clearly entitled to retain the right as they acquired it, without being compelled to make any alteration in their house to enable other people to deal with their property. Section 554. Relief given. In cases of disturbance of easements, the courts have had occasion to discuss the granting of mandatory injunctions more often, perhaps, than in any other subject, because the tort more frequently than elsewhere consists in the creation of some permanent obstacle in the way of the exercise of the plaintiff's right. In Smith v. Smith, Sir George Jessel made the following able criticism of a somewhat common attitude towards them and clear statement of their controlling principle. As to mandatory injunctions, their history is a curious one, and may account for some of the expressions used by the judges in some of the cases cited. At one time it was supposed that the court would not issue mandatory injunctions at all. At a more recent period, in cases of nuisance, a mandatory injunction was granted under the form of restraining the defendant from continuing the nuisance. The court seems to have thought that there was some wonderful virtue in that form, and that extra caution was to be exercised in granting it. To that proposition I can by no means assent. Every injunction requires to be granted with care and caution, and I do not know what is meant by extraordinary caution. Every judge ought to exercise care, and it is not more needed in one case than in another. In looking at the reason of the thing, there is not any pretense for such a distinction as was supposed to exist between this and other forms of injunction. If a man is gradually fouling a stream with sewage, the court never has any hesitation in enjoining him. What difference could it make if instead of fouling it day by day he stopped it altogether? When once the principle was established, why should it make any difference that the wrongdoer had done the wrong, or practically done it before the bill was filed? It could make no difference where the plaintiff's right remained and had not been lost by delay or acquiescence. The argument thus made is sound in reason and has been frequently acted upon by the courts. As will be shown subsequently, it does not apply to the granting of temporary injunctions, and there is also one situation in which a difference may be made between prohibitory and mandatory injunctions even on applications for permanent injunctions. That situation is found in the small class of cases in which, Under the limitations already indicated, the courts may properly give effect to the balance of injury as a reason for refusing an injunction. The reason for this is inherent in the nature of the case. If the balance of injury is to be applied, the fact that the defendant has a structure erected or other work done, which an injunction would compel him to destroy, makes the injury to be done to him by it so much greater than if a prohibitory injunction against it before its beginning had been granted. Section 555. Form of injunction. The form in which injunctions against disturbance of easements are to be expressed has only 2 points calling for mention. The first of these is the curious, indirect way in which mandatory injunctions have often been framed. Criticisms of this form in later cases have been referred to before, and it can safely be said that the courts will discard it in favor of more direct statement of the decree made. The second point to be spoken of is the form used in that class of cases in which, like many nuisances, the tort itself arises out of a balancing of conveniences, and not per se from the mere doing of acts regardless of the manner in which or the extent to which they are done. Such are cases of diminution of light or of excessive or otherwise unreasonable use of a right-of-way. In this class of cases the courts so frame the injunctions as to preserve to the defendant the right to do the acts in question within legal limits. Section 556. Temporary injunctions. In granting temporary injunctions to protect easements, as in other cases, the court does not take jurisdiction for the purpose of settling the rights of the parties permanently, but simply to preserve the property until the legal title to it is established. The title which the plaintiff must show in such a case is not, of course, an incontestable one. He makes out a sufficient case when he satisfies the court that his claim is a substantial one, and that there is reasonable ground for doubting the validity of the title of his adversary. The injury against which protection is sought is that which is likely to occur before the question of title between the parties can be settled, that is, in the limited time before a decision of the pending suit can be had. Therefore the plaintiff must allege facts which show danger of such serious injury occurring in this time, as to require intervention of equity to protect the property, while the title to it is still in doubt. Hence the statement is frequently made that he must show a strong and mischievous case of pressing necessity. This ordinarily means that he must show danger of irreparable injury, though it might be sufficient if he should establish that the defendant was insolvent, or, it would seem enough, if, for any other reason, the legal remedy for the wrong done pending the litigation would be inadequate. As the injunction is always granted at the risk of restraining one in the use of property to which he may eventually prove entitled, and refused at the risk of denying protection to a plaintiff who is entitled to it, the courts may properly inquire into the balance of injury here, and this is the practice followed. Ordinarily the relief afforded by temporary injunctions is prohibitory in nature, and it is sometimes said that mandatory temporary injunctions will not be readily granted, though it is admitted they can be used when a strong enough case is made. The court is always very reluctant to grant a mandatory injunction on an interlocutory application, but where extreme or very serious damage would ensue from withholding it, as in cases of interference with easements, or other cases demanding immediate relief, it will be granted. This reluctance of the courts to grant such injunctions does not represent any difference of principle governing their issuance, but rather a difference in the state of facts. Here, as in applications for prohibitory injunctions, the court must first be satisfied that there is a case of threatened injury for which the legal remedy will be inadequate, and, second, that the balance of injury does not even then require the injunction to be refused. And as the mandatory injunction requires the defendant to destroy or remove property, the balance of injury to him from granting an injunction is by that much increased. Section 557. Effect of change of conditions pending suit. On permanent injunctions, the refusal of a temporary injunction does not affect the decree which will be made at the hearing. The defendant who pending the suit changes the existing condition, as by the erection of a building, does so at his own risk that the right may ultimately prove to be in the plaintiff. He cannot in such cases claim the advantage that the balance of injury might otherwise allow him, because he has acted with full notice of the other party's claim. And it is equally true, of course, that the plaintiff cannot rely upon the granting of a temporary injunction to strengthen his case at the hearing, nor as giving him a warrant to change his position in the expectation of doing so. The decree at the hearing, in other words, is wholly unaffected by the disposition of the motion for a temporary injunction. A defendant who violates a permanent injunction, by doing some work which has been prohibited will, of course, be compelled to undo it. He is in contempt, and it will be a mild use of the judge's discretion if he is required to do no more than this. But when a defendant who had been temporarily enjoined from erecting structures beyond a certain height, violated the temporary injunction by the erection of certain chimneys, the court nevertheless on the hearing refused to order them removed because they caused no material injury. Here, too, the defendant was in contempt and might have been punished for it, but as the hearing showed he ought not to have been enjoined from erecting the chimneys by the temporary injunction. Clearly there was no ground for compelling him to tear down what he might afterwards build up again. The defendant had neither harmed nor helped himself as to the matter of final equitable relief, by disobeying the injunction. Section 558. On temporary injunctions. A very similar question to this may be brought before the court on applications for temporary injunctions. A person who has been served with notice of a motion for a temporary injunction against the erection of a building, rushes work on the building with a large force of men, till the hearing of the motion. Has he effected his case with reference to the granting of a temporary injunction either for good or ill? All courts are agreed that he has not strengthened his position. They will not give any weight to the balance of injury in his favor thus created, as to do so would be to encourage circumvention of the court's jurisdiction. On the other hand, there are intimations in some of the English cases that such an erection will be ordered down even in cases in which it would not have been prohibited, on the ground that the erection of it was an attempt to anticipate the order of the court. This is clearly imposing punishment on the defendant, although he is not in contempt, and may easily subject him to an interlocutory injunction in cases in which, tried by the rules of injunction as measured by the plaintiff's title to it, the facts are not appropriate for granting that relief. It would seem that if such cases were approached just as though the application were for the prohibitory injunction which would have been sought but for the defendant's attempt to gain a wrongful advantage, and if the mandatory injunction were granted or withheld according as the prohibitory injunction would, in that situation, have been granted or withheld, better results would be reached. Even if it is necessary or desirable in such a case to inflict punishment on the defendant, which is, perhaps, doubtful, it is hard to see why it should be done by way of awarding relief to the plaintiff without regard to the merits of his case. The defendant is an object of punishment, if at all, for a wrong done to the court, not to the plaintiff. Section 559. Complete relief. The usual rule of equity to give complete relief, legal and equitable, in a matter of which it has jurisdiction to award any relief, is applied in cases of enjoining disturbance of easements, so that a plaintiff in addition to an injunction may be given damages also. Section 560. Parties. The parties who may enjoin disturbance of an easement are all those whose interest is such that it may be injured beyond the extent for which legal remedies will be adequate. Thus, it has been held that a tenant from year to year may procure an injunction, and so may a tenant whose tenancy had but 2 years more to run. But when at the time of the hearing the plaintiff's lease had, in one case 7, in another, 8 months to run, injunctions were refused. The shortness of the time in both cases being an important element in making proper the application of the balance of injury doctrine. It has also been held that one who had only an agreement to take a lease might have an injunction in order to protect his equitable interest, and an owner of property which he did not occupy was granted an injunction against obstruction of light. Under the same general principle, it is held that a railroad company has such an interest in its right-of-way as to be entitled to enjoin interference with it, as by the building of a bridge over it, or the laying of another track across it. The defendant who may be enjoined is the person who is himself responsible for the wrong. Under this rule the owner of the servient tenement was not enjoined because third parties interfered with the plaintiff's right-of-way,